Yeah, I guess we'll just wait a few more minutes longer, I think, to see who else will be joining us.
Hi Maya. Yeah, if you want to write a brief introduction, like what your background is, why are you interested in this topic, just feel free. I'm really curious about the people who have joined us today and about what really makes this topic interesting for them. And I hope that it's gonna I'm gonna that I will give you at the end some practical advice of what you can do, and I hope that you can start implementing it if you find it useful from today. So I'm curious what um, background you have, what industries you are in, so to make it as useful as possible for you guys.
Tailor it a little bit to what background people are from. Cool. Yeah, whilst we're kind of waiting for more people to join us, I know we kind of opened it up a little bit early, but just to give everyone a quick introduction, my name is Vanessa. I work for CodeBase and we are based in Aberdeen. So CodeBase, if you're not familiar, we're a tech cluster and we kind of work with startups in technology kind of all across the UK. So we've got 3 locations at the moment. Our headquarter is in Edinburgh. And then we've got a location in Stirling and Aberdeen, which is where I'm based. So the whole kind of point of CodeBase on the Couch and the webinar series we've been doing since kind of the end of March now, beginning of April, is kind of keep the community connected over this really weird time that we're all facing and we're all in. And it's just a way to keep everyone together, covering a range of topics that kind of interest and are really useful to the tech community. So we've done things from HR, we've covered things from zebras and unicorns, like kind of tech for non-tech founders. And today we're going to be covering kind of data and privacy and things like that. So so welcome to everyone. Before we get started and before I pass over to Vyara, we will be having a Q&A session at the end. So if you have any questions or comments or kind of anything to do with the presentation, make sure that you use the chat and the Q&A function at the bottom, and we'll make sure we get to those at the end. But yeah, in the meantime, I'll pass you over to Vyara if you're happy enough to get started.
Thank you, Vanessa. I'll share my screen. So should be able to see my screen now. So thank you for joining me today in this quite interesting time. I'd say it's the most interesting data protection time since the GDPR, basically. And I'm curious about what you have already heard about the so-called Schrems decision that came out just exactly 2 weeks ago. And what I'm gonna do is I'm gonna talk not only about it, but about the overall data protection situation currently and how data transfers, which are the basis of our economy in a sense, are gonna be affected this year and in the future. So why am I gonna talk about it and who I am? Well, my name is Vyara. I'm a human rights lawyer, and I've been inspecting issues at the intersection of law and tech for more than 5 years now. And I've been involved in projects that are related to data protection and privacy, but also working in the field of blockchain, DOT, and crypto, and currently working on some pretty interesting AI-related issues, like projects that have AI-related issues that are ethical, but not only. And basically the question that I'm asking myself on a daily basis is, how can we make technology work for us as people and as humans? So this led me to our today's topic that will cover basically how did we get to where we are currently at this level of, let's say, awareness of our data and its cost, its price, and the risks associated with it. And then I'm going to talk more about the Schrems 2 decision and how it's gonna affect data transfers in general, especially when it comes to the United States, but not only the United States. And I'm gonna speak really briefly, because I know it's a hot topic, about the whole Brexit implications that are gonna come up with it. And the final part, I will give you some practical recommendations of what you can start doing right away. So let's start. First of all, when we're talking about privacy and data protection, we might consider it something novel, something that has just emerged out of nowhere thanks to big tech's way of messing with our lives, in a sense, but that's not the case, because privacy has been ingrained in all the main human rights acts, from the Universal Declaration of Human Rights to what we have here in Europe, to the Human Rights Act here in the UK. So more or less it has been around for quite a long time. And what I have to say is that it is somewhat getting worse recently. And the reason is that as technology advances, unfortunately, in a way, some violations of human rights also advance. So we need to be better prepared to tackle them while using the tools that we already have when it comes to the judicial system and remedies. Which brings us to two very important people when we talk about the state of privacy awareness in recent days. So I think you must know one of them, at least. Hopefully you can recognize both of them, but you can see here Edward Snowden, who is an American whistleblower who more or less shaped the way we think about global surveillance and internet privacy. He did that by exposing the amount of surveillance that the US government was up to. And after that, I think the whole discussion about the culture of surveillance emerged. And in the meantime, Max Schrems, who is a Austrian activist, began his own battle of sense, in a sense, against Facebook. In this case, against a company, and questioning the ways and the methods that company was using when transferring his data from the EU to the States. And I'm not gonna tell you the whole story, but it started almost 10 years ago when he first questioned that in front of the Irish Data Protection Commissioner. And why he did that in front of the Irish Data Protection Commissioner, where he is Austrian and the company is American? Well, Facebook, in this case, has its headquarters in Ireland. So according to EU law, that's where you have to question their behavior, more or less. So he brought it in front of the Commission. In few extra steps, it got to the European Court of Justice, which led to the, long story short, which led to the then mechanism of data transfers to the United States to be invalidated, which was the safe harbor. And after that, he brought the same complaint again in front of the Irish Data Protection Commissioner, questioning, okay, Facebook isn't using safe harbor. Facebook is currently using contractual clauses. So can you also say something about that, because it shouldn't be happening? And this case again went to the European Court of Justice, which brings us to the aforementioned Schrems 2 decision, which starting from the question of whether or not standard contractual clauses can be used in data transfers to the United States of America, actually led to much broader consequences, led to the court basically saying that the privacy shield, which is a new mechanism for EU-US data transfers, was invalid. But also, which is, I think, more interesting in a sense. I mean, the privacy shield part is pretty big, but the standard contractual clauses part of the decision basically said you can't use standard contractual clauses that what those are that have been issued by the European Commission and can be used as is for your contracts without reading them and without following them through. It shouldn't be a box ticking exercise. And the same goes for the binding corporate rules, which was later expanded by the European Data Protection Board. And the binding corporate rules are the rules that bigger multinational company uses so that the smaller companies within it can transfer data between the entities. And the third point that the Schrems decision covered was that the data protection authorities of different EU countries now have the responsibility to act when they observe that the standard contractual clauses have not been followed. So just to repeat them real quick, we have the privacy shield that has been invalidated. We have the standard contractual clauses that should not be box ticking exercises anymore. We need to actually read them and follow through. And we need the data protection authorities who now have explicitly the responsibility to act if they see that people's data isn't protected in an adequate manner. So the main discussion right now, I'll just take a sip real quick. It's what's going to happen right now with the European Union. Because in a sense, there's the risk of the EU turning into a data island. That's all that's enclosed and is not transacting in any way data with anybody outside of it, which isn't ideal and which isn't what the court had in mind. What the court had in mind is that data transfers should continue, but we need to ensure that European citizens have their data protection rights protected in the same manner that they are protected within the EU, no matter where that data goes. So the data follows, in a sense, the rules. The rules follow the data, they go together. You can't separate them and say, hey, for example, the United States of America have this legislation where they are not, they can actually just get all your data because there is an ongoing investigation and you would never know that. That cannot happen. And the Brexit implications, which is something interesting that you can keep in mind, but I don't think we don't have any control over that. But so you know, just heads up for all the businesses that will be operating in the UK after the end of this year, the UK will be considered a third country after the end of the transition period. So here the options are either it will make it to the list of adequate countries and different types of negotiations will be achieved, or there would be standard contractual clauses and all this that's happening currently in the United States would also happen with the UK. So now that I covered the very basic part of what has happened, I will go into the more practical details. And while doing that, I will also cover why some parts of the case that are, and the reactions after it that are relevant to this behavior that you can take after the decision. So first of all, please read what you've signed, because it's all about due diligence and risk assessment. Basically, what the court is saying, you can still use standard contractual clauses that are on the European Commission's website. You can just print them out and sign them and let the other party sign them. That's perfectly fine, but also you need to make sure that you follow them. And this brings us to a more broader topic, which is due diligence and risk assessment. Due diligence of the partners you're working with, and risk assessment of your processes, in a sense, not only of your partners' processes, of your United States partners, but your own. Because when it comes to data transfers, we're talking about data, basically, and that data can serve a particular purpose. You're collecting it for a reason. And when you're collecting it, you can ask yourself, do I actually need this amount and this type in order to fulfill the task that I'm collecting it for? And if the answer is no, then you're, in the long term, you are solving a problem by minimizing the data that you have to be accountable for. So this type of things that are related to your overall business logic should be at the very foundation of your activities, in a sense. So after this basic audit of your existing contracts, what needs to be done is to figure out which ones depend on Privacy Shield, and which ones, for example, can also be with an American company, but that company is also using standard contractual clauses or some other means of transfer for these transfers for it to occur. Because, for example, if you are using Amazon, then it's almost 100% certain that they fall within the legislation that's actually the problem here. You know how I mentioned the surveillance? So the court said, following in a sense Mr. Snowden's logic, the court said, we don't think that the United States of America can provide an adequate level of protection to European citizens, because there's this whole legislation that's basically saying foreign individuals that are based outside the US can be subject, their data can be subject to just collection from the authorities. And then once that data is collected, the data subjects cannot do anything about it. There's not a actual redress mechanism that they can use. And for example, especially service providers such as cloud services are very likely, if not 100%, certain that they'll fall within this type of requests by the government. So you need to make sure who you are working with, basically. And if you are really working with Privacy Shield companies, then there needs to be another mechanism that you can still transfer data with them. Maybe it's going to be standard contractual clauses, or maybe it's going to be a combination between contractual clauses and some technical solutions, such as encryption, for example, which is probably the easiest technical way to protect data. So these things need to be evaluated on a case-by-case basis. And then think about the data, which is what type of data you are exporting, which is also related to my previous point that some companies and some industries are more likely to be under government investigation. So in a sense, by ensuring that you are not in this industry, or that the company you are working at isn't necessarily under any investigation in that sense, can prove that you have at least verified that the importer that you're working on, those are the people that you're sending the data to, are secure. Which can happen, the easiest way is to just talk with the importers and ask their lawyers to provide some information at least about the scope of the surveillance law, and even about the previous requests that they've received, and just ask them directly, because they are obliged to provide you that information. And also really important point, because you might be thinking, okay, I'm only sending this to Europe, I'm only transferring data with an European company, but you need to also check the subcontractor that company is working with, because it might be working with somebody who is relying on Privacy Shield, for example, for the data transfers. And the last thing is to just think about other ways to store that data without it leaving the EU, or not even the EU. Here I've written local use storage, but you can also think about the EEA as a broader community, and or check the list of the countries that the Commission has decided provide adequate protection, such as Switzerland, for example, Israel, Canada in some cases, and just reevaluate the risks and the business logic of what you're doing. So I think that's a very brief overview of what's going on. I did it in 20 minutes, okay, happy, even 15 minutes. And I'm happy to take your questions now. I try to leave as much time as possible for questions. And here, the slide, you can see my contact information if you want to get in touch and discuss this further, discuss your own problems that you're facing and what might emerge as problems after more, for example, more authorities like the FCA, not the FCA, but ICO have issued statements. So yeah, let's give the floor to you, and I'm really curious what you might have in mind.
Oh, thank you so much, Vyara. I hope a big, massive virtual round of applause for you. Probably can't hear, but I'll be clapping. Yeah, that was really interesting, and I guess it was like what we discussed prior to the webinar starting. It's kind of, we're just scratching the surface, aren't we, of what's going to happen, and it's what procedure is going to happen after that makes the biggest impact. So yeah, if anyone has any questions, we're opening up the floor for a discussion. If you have any comments or what you thought about the judgment, or you know, if you need any more practical tips to get you through this period, then yeah, make sure that you ask the questions below. I mean, no question's a stupid question around here. So we seem to have a really great mix of people joining us today. So I mean, if you want to talk a little bit more, we can always unmute you as well, and you can chat directly to us. But yeah, there was something from someone who doesn't really have a background in data. You know, you mentioned third country. What does that kind of mean, you know, for someone who's a bit of a novice like myself?
Oh yeah, so a third country basically is a country that the European Commission decides to not provide enough protection for the EU citizens' data, because here we have different levels, so to speak, of adequacy in data protection. So we have the EU countries, that all the member states of the European Union. And then we have the extra layer of all the European Economic Area, EEA countries. And then we also have a list of extra countries that have passed the validation of the European Commission that they provide enough protection, in a sense. So the list, you can find it on the European Commission's website, but countries like Israel are there, Switzerland, Canada, but there's the exclusion of certain areas. And also the United States was there with a Privacy Shield. So a third country is any country that falls outside these broader categories of countries that have considered to be adequate in their protection.
Thank you. Thanks for explaining that. Kind of makes a little bit more sense to me now. But yeah, guys, don't be afraid to ask a question. We kind of want to get a bit of a discussion going today. So, but yeah, even if you've just got a comment to make. But yeah, you mentioned something about kind of reading contracts and just making sure you read before you sign anything. I mean, for Joe Blogs on the street who want to sign up to something, and they've got a risk of popping their data, they don't know where the data's going, and they've got to read this big massive stream of detail and information that they just can't comprehend. Like, what's there going to be moving forward to be able to make that information into like more digestible forms? Because I know for sure I'm really bad for that, just clicking, yeah, I read the terms and conditions, yeah, I've done this, I've done that, but this is really important. It's something that probably isn't being put a big massive pressure on, and something that everyone needs to consider. Like, what do you kind of think about that kind of moving forward past this judgment?
Oh, I love this question because it kind of brings me to the whole, I've had this discussion various times, and I think that one of the most interesting outcomes from the GDPR, I intentionally did not mention GDPR, I think, at all during this presentation, because I know you're all know, I don't want to hear about GDPR, but it's there, its spirit's there. It's just, it doesn't have to be mentioned all the time because it's kind of part of our lives in a subconscious way. Outcome of this is basically that right now data protection has turned into both a competitive advantage if done right, and a competitive disadvantage if done wrong. So what we observed during the COVID early days and the boom of Zoom usage was really a lot of people raising the issue that, hey, actually Zoom isn't so great at protecting your data. People can interfere with your video calls and everything. And they took notice and started just bombarding us with press releases saying, hey, we've hired this expert, we're working with this company. So they kind of turned it around into something that they are trying really hard to turn into an advantage. So in a sense, I think we are really bombarded with information right now, but what companies can do is that they can reassure us as customers that they're doing as much as they can to protect our data and build trust through small things, like the way they communicate what they're already doing, the way they even communicate their cookie banners. The wording on their cookie banner shouldn't be, yeah, agree to this. It can actually explain something because it's not that hard. It's like basic user experience, user interface thing. So I think companies can do a better job at this, at explaining what they're actually doing and who are they sending the data to and what's going on with the data, why are they even collecting it in the first place. And I think it's slowly turning into a culture of sort. So people are actually using this as their advantage.
Mm-hmm. Yeah.
So I think, yeah, it's the natural way the whole business logic is gonna go. They're gonna benefit from the fact that they're compliant, because those that aren't compliant are just gonna have pretty massive PR crisis to deal with.
Yeah, I remember when Zoom, obviously everyone was really unprepared for this pandemic that we were going under. So yeah, I remember Zoom being quite, it was kind of like going on in the background, and then obviously everyone started using it. And then the question is, what happens to the data? Like, where does it go? And I think even Zoom was unprepared. They were like, you weren't expecting everyone to be suddenly using it. So, but no, that's really interesting, because yeah, I'm just conscious of the fact that I should be reading like these kind of cookie banners and the data stuff that pops up, and being really conscious of that kind of since kind of learning about this this whole new judgment thing. But we have had a couple of questions come through actually. So we'll answer Graham's question actually. He says, great talk, thanks Vyara. One point I'm not clear about yet is, assuming you're using a US provider such as Azure or AWS, how much legal risk difference do you think there is now between storing the data in the US or storing it with a US provider in the EU? given that the US authorities can legally access it even if stored in the EU Cloud Act, etc.?
Great question. And I'm gonna jump into it, but before that, I just want to finish on your last question. Don't feel bad about not understanding what you're reading, because it's actually the company's obligation to explain it. It has to make this thing clear. And so if they're not making it clear, then they're not doing a good job. It's not the consumers, like the reader's problem in this case. Mm-hmm. But to answer the question about that, Graham, I was expecting a great question from him, and here it is. So basically, there's this big thing, and let me go back just slightly back and explain the whole. Explain in a more nuanced way the situation that the US is right now. So they have the FISA legislation, that is the Foreign Intelligence Surveillance Act. And according to Section 702, I believe, of it, they can request data from service providers, from US service providers, when that data concerns foreign citizens, and especially citizens that are based outside the US. So here's a hierarchy of rights in a sense, because they cannot do this for US citizens, but they can do it for example, European citizens in this case. And especially when it comes to cloud service providers, such as Azure, it's 100% certain that it's gonna fall, basically that the data is being transferred to the states for such type of services will fall within the FISA. So basically, US government can request this type of information from the service provider. And here is the more interesting thing, that FISA isn't actually doesn't only affect, like, for example, physical databases that are in the States. It also affects databases that are stored in the US, in the EU, but are operated by American companies and are storing, for example, EU data. So in a sense, the American government can access European data that's stored in the EU simply because it's governed by Amazon, for example. So it's a problem. And also, but we're not perfect here in the EU as well. And especially, I think the UK will have more significant problems when it comes to data collection and data transfers after Brexit, after the end of this year, because of Five Eyes and their other practices. So in a way, you can ensure that it's, you are doing the best that you can by working with an EU-based company or a EEA-based company, or a company that's whitelisted in a sense. That also extra step needs not, that also isn't working with companies that are privacy shield companies or are transferring data to third countries. So that's the cleanest way to do it.
Cool.
I hope that answers the question, Graham. I'd love to further discuss it.
Yeah, if you need further clarification on that, Graham, feel free to leave another question. We'll get around to it. Thank you so much for that. We have had another one come through from, is it Sosha? I apologize for any mispronunciation of names. She asks, thanks, Vyara, what's your view on the likelihood of a federal privacy law in the US given current climate?
I think that's going to be the best solution, that in a sense, that the most perfect solution from a European point of view would be that the states would change their surveillance legislation, A, and B, that they would adopt a way of handling data on a more centralized way, because now we have different layers. We know we have the federal layer, we have what the separate states are doing, and for example, there is a really big difference of what different states are doing at the moment with data. Because on the one hand, we have the California Act, the CCPA, that is pretty strict. That's basically the closest to GDPR that the American state has gotten to. But we have most of the states do not have this type of legislation. So it's really complicated. I think a federal level legislation would really solve this. And I know that there have been talks about it. I don't know how far they've gotten, but from what I'm seeing, it's gonna be, my opinion is that it's gonna be bottom up rather than just something appearing out of nowhere in Washington. Because I think that more states are adopting new legislation that covers data protection in a broader way. So just in time, I think when enough states have adopted their own legislation, there's gonna be something going on a federal level as well.
Oh, thank you. Thanks for that. Yeah, if you have any more, need any more clarification on that, feel free to leave another question. But we'll move on to Miroslava. They've left two questions actually, but we'll go with the first one. The EU decision only concerns future transfers of data to the US, right? The ones already made under the Shield remain valid?
So yeah. So in a sense, the Shield has been invalidated as of last week. And what's interesting is that now companies can say, hey, I don't want to be under this mechanism anymore. I don't want to be a Privacy Shield company anymore. I'm canceling my certificate in a way, in a sense, because it's not working anymore either way. But that does not mean that these companies are not obliged to take care of the data they have already collected under Privacy Shield. So here we have two separate sets of data in a sense. One that was under Privacy Shield that company still has an obligation to follow under Privacy Shield, and all the data that's going to be collected under different mechanisms.
Mm-hmm.
So yeah.
No worries. Hopefully that's answered your question, Miroslava. Got another one as well. Basically, if so, we have relied on the Shield for the transfer. Now we have to sign SCC with the contractor. If that was the only mechanism that was being used, basically all the future transfers and all the even opening that data that you already have basically is against the law right now. So you need, right away, you need to start thinking about new mechanisms that can be adopted. For example, it can be a standard contractual clauses, if that's relevant. You can also add some extra technical protection and guidelines. But the first step is always to just contact your partners and ask them about what they're actually using in order to be able to get data from the EU. And after that, start discussing how this can be improved, even if they are already using standard contractual clauses. You should evaluate the situation all over again and start thinking about ways to ensure that you have taken the necessary steps to make this even more secure. Cool. Hopefully that's answered it, Miroslava. Again, if anyone wants to chime in and make any comments, then feel free to do that. We have time for some more questions, so if anyone has anything else that they want to talk about, just make sure you pop it in the Q&A or the chat. We had a question come through from Maya in the chat, actually. Thanks so much, Vyara. What's the likelihood of the US and EU Commission reaching a new agreement that would replace the Privacy Shield and comply with the latest decision from the European Court of Justice?
That's a great question, because that's one of the big question marks that's facing us right now. And in a sense, that was the approach that they adopted after Schrems 1. They just decided, let's go with a different mechanism. That's basically almost exactly the same thing, but let's try. Maybe it will work, and it didn't work. And I hope that they're not gonna do it for a third time. And especially considering that, just a remark. Currently, the European Commission is working on a new set of standard contractual clauses, and they were postponing the publication of those because they were waiting for the Schrems 2 decision. So in a way, I'm hoping that they'll cover enough of the problems in those, and they can be used again, not as box ticking, but actually being read and implemented. For some of the transfers that will be taking place with the states. But if we are to adopt a new privacy shield, or as some colleague referred to it, to a safe harbor 3.0, we need to make sure that it's not going to be like the last two. And I think that's going to take a lot of time. For example, I think privacy shields discussions and everything took around 10 months. So even if we were to adopt a new version, it will take some time. So we'll see. My answer is we'll see, and I hope even if the Commission decides to adopt a new version of it, it's going to be actually a new document, not just a version with slight differences.
Yeah. Thanks so much. Hopefully that's answered your question, Maya. Again, if you have any other comments or questions, feel free to leave them in the chat or the Q&A below. The one thing that's kind of like really surprised me, I guess, about all of this is why it's not been kind of covered a lot more in the media. Obviously, we're going through a really tough time, so there's other things that have kind of taken precedence. But in your opinion, like, is it something that the media is also not covering and not telling the public, and we're not then aware of what's happening unless we dig for that information? Kind of like, what's your opinion on that kind of thing?
Well, in a sense, yeah, in a sense, I'm really happy that I'm doing this webinar, because it will help me figure out what's the standard level of, even though I guess most of the participants have a level of understanding of the problem above the standard one, but I need a reality check in a sense, because inside my bubble, it's all about Schrems. Just in the past months, it's been all about Schrems, and I'm losing touch in a sense of what goes out and gets to the people who would be directly affected by this type of decision. And the last thing I want is that we'd have the mass panic that was that we experienced in 2018, right before GDPR. And GDPR was there. It was like we had 2 years to get ready for it. So it was, again, I think that partially maybe the media wasn't covering it enough. Maybe we as lawyers and professionals working in this field were failing at telling people that this is important. You need to consider it as early as possible. And I think, in a sense, what we risk at seeing here is that will turn into the next GDPR type mass hysteria, in a sense. And I want to avoid this and just tell people that you don't need to panic. It's all right. You just need to really evaluate what you're doing and why you're doing it. And at the end of the day, it will actually improve your processes and the trust that your consumers, your users have towards you. Because it's, at the end of the day, that's it. It's just, you need to protect these people's data. That's it.
Yeah, I think I'm definitely someone who just doesn't keep, like, I'll just consume what the media gives me, the news. So I'm probably your perfect target audience, actually. But yeah, when GDPR came out, it kind of just hit us like a brick, really. And we were then told at work, we had to do certain things, we're not allowed to pass on information, etc., etc. But I suppose it is a case of being able to digest that information, because a lot of it is very legally technical. Joe blogs on the streets just wants something just to be like, you can't do this because these are the consequences. And I feel like because it's just so big, such a massive topic, that it just kind of gets a bit, people then tend to lose a bit of interest when they feel like it directly affect them. So but no, I definitely I'm probably one of those people that need to need to read up a bit more about it and things like that. But I guess like these kind of issues don't crop up unless something major happens, like Zoom, for example. Like I never really thought much about it until they were like, oh, actually everyone's using Zoom now, and Zoom's like incapable of like coping with all of this kind of backlash about encryption, what's going to happen with everyone's data. So I think it's only until something massive happens negatively in the media is when then people start perking up and like, why didn't we know about this 2 years ago? And it's like,
no, exactly. There's such an information overload that I don't expect people, I don't expect myself to be able to just keep up with everything. So I think it's up to the experts who are working in this field to raise awareness as early as possible, and hopefully not to bring panic, just because most of these things can be tackled by following steps that are mostly just figure out what you're actually doing and what you want to be doing, and what, in this case, how much data you need and who you have really have to send it to in order to achieve your aim. So it's really not that complicated, and you can always provide, like, for example, your clients or the people that you are informing about this with easy steps that can be followed, such as like think about who you're working with, like first step, and where he's located and who is he working with, and things like that aren't that complicated. But especially when it comes to EU regulations, there are a lot of paperwork involved that I think just kind of scares people and puts them off. But at the end of the day, all these regulations follow specific logic. And as I try to explain, the privacy and data protection things aren't something new. It's just our rights that are being expanded because violations of those rights are being expanded in a sense. So it's just natural process of us trying to protect ourselves in a sense.
So we've talked a lot about, I guess, business, things being stored on the cloud, for example, but as like an individual, as a user of the internet, user of data, someone that might also capture data, like what, except from reading the cookies banner, reading the privacy policies that pop up, like what other tips and things would you recommend someone for like me to just keep in the forefront of our mind when we are handling data, whether that be my own data or passing it on to a company? Like what kind of little things can I do to kind of keep in the forefront of my mind?
Well, I think it's impossible for us to do a proper due diligence of all the companies that we're sharing data with, especially as those are, I think, hundreds of thousands of companies basically. But as like a general rules, I think we should really be aware of the amount of data we are leaving as a trace all over the internet, basically. So especially if I was taking just side note, I'm taking digital marketing course, so I've been covering Google Ads, among other things, and I had a really practical project that I had to submit at the end of that course. And by going through all the settings of like the ad that you are intending to launch, I was thinking, oh my God, it's really, I've read about it. I'm aware, I'm perfectly aware of the human being and as a privacy professional of the amount of data. But right now I'm seeing this in action, the way that they can just basically they can pick you just by picking different characteristics of yourself that you've left as traces all over the internet. Basically, they know that you prefer shopping online. They know that you leave specific kind of comments on their Facebook posts. They know that you love photographing your cat, and they're gonna bombard you with cat-related ads at the end. So they know all about us, and it's the big tech that doesn't have a face. And actually, those are the companies that are using this information to sell us things. And when they're selling us things, that's the better version of the usage of the information. It's when governments and other companies are using it to serve for surveillance purposes, to watch over us, to give us scores that will affect our lives. That's where the actual problem is. So, Facebook and data and ads, it's horrible, but those are actually the better of two evils. It can be worse, and we should be cautious, because if ads people know that much about us and the government has access to that information, then the risk is enormous.
Yeah, it's actually, I went through a couple of those kind of courses talking about analytics and targeting ads and things like that, and it's genuinely terrifying how much information that I have also put out on the internet, I'm not even aware of it, and I'm like, oh, I'm seeing ads for this. How did they know that I was thinking about going on a camper van holiday, for example, and they're selling me a camper van? It's I must have actually spoken about it, or I must have inadvertently Googled something, but it's actually terrifying. And kind of going through those kind of courses about analytics really kind of hits it too close to the heart, I guess.
Exactly, yeah. So just a simple advice: be careful what you're posting, and clean your cookies, and use Brave, for example, or other browsers that, at least in a sense, at least you can make money out of your ad watching activities and things like that. Just small steps, but because I'm not gonna say just leave the internet. It's because I'm not doing that. For example, I'm very active on social media, but that's a risk that I'm just taking by acknowledging that it exists. So at the end of the day, it's all about just making a personal decision about the risk and about the data that you're willing to share in order to get a specific service.
Yeah, for sure. I think that's really good advice. We've actually had some questions come through whilst we were talking from Graham. Another EU law / GDPR controversy in the pipeline is the Privacy International case before the ECJ, in which the Advocate General said that French, Belgian and UK government surveillance practices are illegal. Any thoughts on linkage to the Schrems 2 issues?
It's gonna be really interesting. That's why I mentioned Brexit in the presentation, and but I kind of just marked it. But I think all those decisions are gonna pile up and reflect on the future data transfers between UK and the EU. And I think it was quite funny. I think I mentioned this to you in our conversation before the webinar, but it was really interesting to observe the reactions of different governments and the different data protection authorities in the member states. Because, for example, the UK government issued a statement that was basically like, oh, we are very disappointed by the invalidation of the Privacy Shield. Whilst most of the data protection authorities were like, we welcome this decision, because it was, even in the wording, you can sense that it hit way too close, and that I think the government, even the UK government, is already worried about the implications that Schrems 2 will have, and about all the practices that they've had throughout the years will have on the future of data transfers with the EU. So we should also follow these other decisions and all that's going on, because it's gonna impact all of us, basically.
Yeah, Graham's has said, yes, all this plus Brexit equals headache.
It does. Yeah.
I think Brexit's just kind of been pushed to the back of everyone's mind at the moment. I've just started seeing adverts pop up and I'm like, I totally forgot that is happening. So I think it's just kind of, this pandemic has kind of really overshadowed, the the Brexit issue. So, but yeah, hopefully Vyara's answered that question for you, Graham. But feel free to leave another comment. I think we have time maybe for one more from you. The decision is not only about the US. If another third country has the same problems with it that the US are having, the recommendations for data transfers are the same.
Absolutely, yeah. So it's about the US, but it's applicable to all third countries basically, and especially to all the data transfers that rely on standard contractual clauses. It's applicable to all of them. And in the US, in this case, we have it's not a precedent because it already happened with Schrems 1, but we saw that the European Court of Justice does not have a problem to invalidate decisions made by the Commission if the court does not recognize them as adequate, as providing adequate protection. So even if we check the list of countries that have kind of gained their adequate status, they're all at risk of similar decisions, to be honest. So yeah, it affects all third countries. It affects all countries that are within the list of adequate countries. It affects basically all the standard contractual clauses based data transfers.
Thanks for that, Miroslav, for that good question. Hopefully Vyara has answered it. You know what, we could spend all day talking about the subject. I think it's just one of those topics that we'll never be able to get to the end of any firm answers. But you know, if we do have time maybe for one or two more questions, so feel free to leave them now, or if not, feel free to contact Vyara separately and have a little bit more of a discussion. But like I said, it's a massive topic, and I mean, you successfully managed to cram it all in at least a little bit into this hour session. So hopefully everyone's been able to take something away from it. But again, if not, feel free to get in contact. I'm sure Vyara likes a good discussion and talk a little bit more about it. But yeah, in the meantime, if no one has any more questions, I guess we'll finish up almost bang on 3 o'clock. So yeah, just a massive thank you, Vyara, for this session. It's been really interesting, I guess, in a more business, legal, technical side, but also on a personal side. I'm definitely going to be more aware of reading things and keeping that in the front of my mind when I'm dealing with internety things. It's a shame because they call it cookies, and it's just such a cute name for something that actually is quite serious. It's something that I just never thought.
I'm leaving forever.
I'm leaving a trail of cookies. It just makes complete sense, but it's definitely something that everyone needs to keep to consider and kind of keep in mind. But yeah, thank you so much. A virtual round of applause from everyone. If you want to catch up and watch this again, it's going to be uploaded onto our YouTube tomorrow. But we don't have any CodeBase on the Couches scheduled at the moment, but keep an eye out on our website for more events, networking things that is happening. We'll probably be doing this for a little while longer, I would imagine. But yeah, in the meantime, thank you so much, and I hope everyone has a great rest of your day.
Yes, thank you so much. Thank you for organizing this. And I think I'm connected with some of you on LinkedIn, but to those of you that aren't in my network but want to be, I'm sharing a lot of information, like a lot of articles and thoughts on data protection, but also AI, ethics, and blockchain, the things that I'm interested in on a daily basis. So you can find me and we can connect there. And also you can always say hi at vyara.io. And yeah, I'd love to keep in touch and continue this discussion. And thank you for organizing this.
You're welcome. Thank you so much for being a part and taking time out of your day to talk about this topic. Thank you so much. Thank you, everyone.